So David, let me ask you, and again, going back to the issue of the courts and everything, you're in front of a judge, you're representing yourself in front of the opposing counsel is Marshall Thompson. Do you think that people should be able to watch your hearing online?
I do, actually. I prefer they do. I understand, correct me if I'm wrong, but I understand the Texas Supreme Court's hearings are all recorded, the U.S.
And
Supreme
archived.
Court, and archived. Is it true that the appellate court hearings are recorded and archived as well?
I don't know about the archive things, but I know that they have been broadcast online because I've watched them as well.
Yeah.
And the thing about like the Texas Supreme Court and the appellate courts, they don't have a little button down here that says "Do not record, do not record."
Right.
You know.
Right.
Why is it that family courts feel that they have to hide things? And they say, well, it's privacy issues. That's crap. Any lawsuit, you lose your privacy. So I mean, I just think that there's a lot of corruption there that they are, or incompetence. I don't know whether maybe it's a combination of both, or maybe to see that the fact is that family law is a misnomer. It's family court opinion. There's the law that governs it so often violates our fundamental rights and our constitutional rights that the law itself should be tossed. But anyway, so you
Well, no, I think you're right about that comment. For a long time, fundamental rights have been violated with the current state process of determining child support, child custody, for a long time. You had asked about my history.
Right.
It's a long history. It's been very diverse. I've had the honor and the pleasure of being an adult and child psychiatrist for 25 years, working in a variety of treatment settings, as well as adult and juvenile justice, being exposed to different evaluation processes, and seeing firsthand, the devastating effects of single-parent households or multiple generation households or once removed generation parenting households in the justice systems. I've had a lot of exposure to psychological testing, because practically almost a great majority of patients I have cared for have already had psychological testing. So it's a pretty standard exercise in most treatment settings.
And the legislature has coined you an expert. They've recognized you as being an expert in your field.
Well, yes, I've testified individually, not associated with any certain rights groups, but in support for children having equalized parenting with their parents in unmarried or divorce situations, and the benefits of that. I'm considered an expert. I'm board certified. I've been board certified in adult and child psychiatry for a long time. Yeah.
No, I really wanted to get that out there again, just so that people know that you're just not an average Joe out here. You've devoted your life to this, because if I remember correctly, weren't you going to be like a heart surgeon or a brain surgeon?
I was, yeah.
Okay.
I was going to be a cardiothoracic surgeon initially, yeah.
And then what caused you to change?
I was, I think, exposed to psychology, psychiatry for early on, and it just, I just enjoyed it, turned me on, and so I decided to change. But I think the overriding principle is the issue of peer review. We're always operating under checks and balances and peer review.
Right.
And I think that's what is the main motivating factor of quality of care. You
Yeah.
know? And then, there's the malpractice reform and things such as that that have occurred in the field throughout the years, and defensive medicine. But when you have the ability to have kind of overview of your work, you tend to check and balance yourself. You tend to be more mindful of what you're doing versus when you do not.
Right.
And you also have accountability.
Right.
So I work with the state, the Inspector General's office. I work with the state board in reviewing other psychiatrists' work for standards of care. I've done that for a long time.
Yeah.
Yeah.
I keep on going back to my own profession and what I do. And this whole idea, I cannot understand why you would not want to have multi-levels of review. I mean, first, when you're in training, you do something, you submit your comments, whatever, you write your report, it gets critiqued, it gets sent back to you, redo this, redo that. If there's any questions, you consult with your supervisor. Sometimes you consult with a supervisor about that supervisor. I mean, writing a report is not an easy thing to do. And then after you do go through this process, you go through this process, there's another person that reviews, and I believe there's even a fourth level of review. And then in some situations, there can be a fifth level of review. This is typical for what we do. Now, the fifth level of review I don't think is so typical, but I mean, there's multi-levels of review, consultation, and what I hear you saying is that this doesn't even exist for child custody evaluators. One person can make up anything and it flies. And where is, like you said, the work product review? It's incomprehensible to me that this is even permitted.
I think that in the practice, in terms of forensic psychiatry, in which I've had the opportunity to be supervised by some really excellent forensic psychiatrists in the past, there has to be scrutiny of the information that's being taken in. Even to the point where you at times ask, why is this person telling me this information at this time?
Right.
What's the motivation underlying that? And you have to be aware what the law is. When there's a child custody evaluator that attempts to limit your association or freedom of speech,
right,
and violate your fundamental rights in a fee agreement, violating the fiduciary duty, and then attempts to interfere with the process of discovery by wanting a court order preventing either party from contacting previous cases. Either there's a clear willful disregard for the process of the law, or there's just a lack of knowledge.
Yeah.
In addition, there's been other incidences. I think we mentioned it related to different policies of different state agencies that Alissa Sherry is just not aware of. And
right.
Over the practice of whatever many years she reports she's been practicing, she should be aware, much more aware, and have an expertise in the law than a pro se litigant whose background has been adult and child psychiatry.
Right.
Or any pro se litigant. But I think the issue is many pro se litigants or even any represented litigants are just at a disadvantage. Right. Because they're considering this person as the expert. Yeah.
Yeah.
And it's rather intimidating at first.
Yeah.
It can be intimidating. You know.
Yeah.
But I think when you truly examine the situation, you begin to see the fraudulence in the situation, and it's rather angering.
It is.
I think it's disgraceful to the field.
It is, absolutely.
Actually, it's very to the field that I've been in, to my colleagues who have practiced as ethically as they can, who have dedicated their lives to the outcome, the well-being of children, and parents and adults. It's a disgrace.
And I'm 100% with you. And again, going back to my own, where I work, it's not just the reports that people can look at, they can look at our work papers. And I mean, it would be very interesting to see what her work papers say. I think that all of this stuff should be open. I know that there have been times that, I've been in conflict with a supervisor about something, and I'll pull up my work papers. I want to make sure that what I'm saying, either that I've supported, or if somebody else overrides me, and if anything bad would have happened, I would say, well, my work papers, there was a situation that happened one time, and the first thing that I went to was my work papers, what did I put down in here? And everything was good. So, but I think that what the points that you're making about Alissa Sherry having, and child custody evaluators in general, but Alissa Sherry in particular, having absolutely no accountability, and then trying to use the law to prevent other people from accessing the work product that she has done, if she's even done it. Who knows? She just may have written something up.